Now we're going to talk about the transfer of instruments. Again, we have the difference between assignment and negotiation. The assignment falls under contract law. If you are assigned rights, you become the assignee. But like I said, you take subject to the defenses in any claims of the person you're presenting the document to. And then we have a concept called negotiation, and this is the transfer of a negotiable instrument in such a way that the transferee becomes what's called a holder. And while you might be the holder and be the one legally entitled to payment on that negotiable instrument, we might, and hopefully, depending on other requirements, that you further qualify as somebody called a holder in due course, and you obtain more rights than what a mere transferor would get in assignment, meaning you may be able to avoid any defenses or claims. So there's two methods of negotiating, and that's going to depend on whether the instrument is an order instrument or a bearer instrument. So our two methods of negotiating, depending on the instrument, the order instrument and the bearer instrument. The order instrument, you have a negotiable instrument, like I said, with a specific person named on it. And you need two things for it to qualify: a physical delivery of the instrument and endorsement, which should be spelled Indorsement, not with an E, but a little late making up my slides here. So hopefully you guys don't mind my typos. So a negotiable instrument payable to a specific person. Here's a check. It says payable to the order of Rebecca Fox. Okay? You give it to me, right? You physically deliver it to me, and in order for me to use it, I have to place a signature on the instrument for purposes of transferring the ownership to the next step. Okay? So if you hand me a check payable to the order of Rebecca Fox, and I take it to the grocery store, in order for me to then transfer it or get my payment, what do I have to do? I have to endorse it. And I sign it, and I do that by signing the back, right? What if I didn't take it to the bank? What if I owed somebody money? It says there's a check. You gave me a check for $500 payable to Rebecca Fox, and I have it. And what if I do not want to cash it? I owe somebody else $500. In order to now transfer this, I have to physically deliver it, let's say to the person I owe $500 to. And in order for it to be transferable or effective, because it's got my name on it, I have to sign it. I have to endorse it. So then I sign it, and then I give it to that person. Now that person has this check that they can then transfer it to, or go to the bank and cash. That's another form of transferring. I want to stop at this point because we're going to go through the channels when we get to a holder in due course. I'm just showing right now there's two ways of transferring documents depending on which one you are. Now you have a bearer instrument, right? And the bearer instrument says pay to the order of bearer, or pay to the order of cash, right? What do you need? You don't need you don't need endorsement, you just need physical delivery, because you don't need the endorsement because it's whoever possesses the document. Now I ask you, do you see any problem with that? Yes. What if this document's lost? What if it's stolen? You write a check out to me, payable, it's $500, and you write payable to bearer. Here you go, Rebecca. Boom. Here's your check, and I got it. I could give it to the next person I owe $500 to. Here you go. It says cash. It says bearer. Anyone who possesses it can take it to a bank and have it cashed. No endorsement is required. And this can go down the channel of lines. Well, I owe this person $500, so I'll give them that. So it's whoever possesses it. So clearly, if you're holding the check that says payable to bearer or payable to cash and you lose it, somebody who finds it can certainly then cash it or transfer it or use it. So endorsements. We have a few different types of endorsements, and like I said, the order instrument requires it. It's commonly endorsed by writing on the back of the instrument. We have the endorser, that's the one that transfers by signing and delivers. And then we have our endorsee, who is also the holder to whom the person is endorsed or delivered, right? All right, let's talk about a few different types of endorsement. We have the blank endorsement, and that's just the signature, right? You just sign the back. Converts the order instrument into a bearer instrument. What do I mean by that? Anyone can cash it once you sign it. So Becky endorses a check in blank, meaning just signs the back. It's written out to Rebecca Fox, let's say. $500 check, it's written out to Rebecca Fox. All I have to do is sign it, bring it to the bank. If you hand it to me in my office and I sign it and then I drop it on my way to the bank, that's considered, it's good. It's considered, it converts to a bearer. Anybody at that point can pick it up, they can cash it, they can transfer it to the next person, not by signing, just by passing it. It's endorsed, it's got my signature on it. There's nothing else otherwise. It's called a blank endorsement. So like I said, that person who finds it, they can transfer it. They can give it to the next person. And then we have this concept called special endorsement. And it contains the signature of the endorser and identifies the person to whom the instrument is made payable to. So this is a little bit more protection on the check. So on the back of the check, you give me the check payable to Rebecca Fox. I got my name on it. But now I want to transfer it to the person that I owe money to, and maybe I owe money to John Doe. So what I do is I write on the back, pay to the order of John Doe, and then I sign. So that the next signature in line, when you transfer it, remember our order instruments, you need physical delivery and an endorsement. So for John Doe to endorse it, to transfer it or bring it to a bank, he has to sign his name. So you can kind of put that restriction on it. It has somebody's name on it. A check made out to cash. Let's say there's a bearer instrument. It's made out to cash. And then I write on the back of it, it's made out to me. I write on the back of it, paid to the order of John Doe. And then I sign it. Now I've just converted a bearer instrument into an order instrument, because now John Doe needs to sign and deliver in order to transfer that document. We have something called a qualified endorsement, where the endorser, upon a signing, promises to pay the holder. Normally, when you sign these things, just to back up a little bit here, generally an endorser who signs, in those last two examples I gave you, promises to pay the holder and any subsequent endorser the amount on the instrument. And if the instrument is later dishonored, we have to pay. We'll talk about liabilities in a second. We're talking about endorsements, the types. Qualified endorsement disclaims liability. So if I signed the check on the back, but I say without recourse, and I sign my name, that means I can't be held liable. There's a disclaimer of liability on the face of the check. So if I'm transferring to John Doe, or giving the check over, I can write without recourse. And then we have a restrictive endorsement. This requires the endorsee to comply with certain instructions regarding the funds involved. Does not prohibit further negotiation of the instrument. It just limits the funds that are involved, restricts the funds that are involved. What do I mean by that? When you write things like for deposit only, pay any bank, pay Smith Jones. It's got special instructions. You're going to pay this. You're going to cash this check to pay Smith Jones. It would be improper to say, pay to the order of Smith if Smith washes my car. Right? That's restricting the transferability. It's adding a condition. So you can't do that. But you can put things like for deposit only, which means this money is only going to be deposited. You can't do anything else with it. You can't walk into a bank and say, well, then can I have the cash because the check says for deposit only. You can have a combination of these things, right? You can have a without recourse and sign, and that becomes a blank/qualified endorsement, which means you could turn it over to the next person and turn it over to the next person, but it says without recourse. It's only saying I don't have any liability on it. You can also write for the deposit only, without recourse, signed, Rebecca Fox. You can use any sort of combination of these. And as I showed you in the examples, you can end up flip-flopping back and forth between a bearer instrument and an order instrument, depending on what language you actually put on the document. Okay, transferability and liability. So a holder is a person who possesses an instrument payable to the bearer of, or by identity, identified person possessing it. Right now, these people are deemed just ordinary rights, mere assignee, right? They haven't acquired any rights or liabilities until I tell you the requirements for a holder in due course. But as of right now, this is where we stand from what we've done so far. So back to my Bob. We're going to come back to Bob here and Nora. So Bob sells a bushel of apples to Nora for $5. In exchange, I said Nora executed a contract, but let's say she pays with a check for $5. A few days later, Bob buys some oranges from Pat for $5. Instead of paying cash, Bob endorses Pat Nora's check for $5. Can he do that? Yes, he does that. How does he do that? He signs the back. Or he writes pay to the order of Pat and signs the back. So when Pat demands the money from Nora's bank, Nora will pay, or Nora's bank will pay, and everyone will be square. But then what happens if there's no funds in the account, right? The account's closed, there's a stop payment. Now what happens? Because as of right now, from what I've told you, Pat's a holder. Does he have any recourse? Does the bank have to pay? Where's his recourse? And if he's merely an assignee or a holder, he may have to go back and deal with Bob. But let's see if he qualifies for somebody who has more rights, our holder in due course. There's someone who takes a negotiable instrument free of all claims and defenses. Okay? And what you need to be a holder in due course, or have holder in due course status, is you have to have these 4 things. You have to be a holder of a negotiable instrument. Okay? You have to have given value for getting that negotiable instrument. And you have received that in good faith without any notice that the instrument is overdue, been dishonored, that is subject to any claim or defense, contains any unauthorized signatures or alterations, basically calling into question the authenticity of the document. So the gist is a holder in due course honestly pays for an instrument and doesn't know anything's wrong with it. Okay? The gist. Holder in due course, they honestly pay for the instrument and does not know anything is wrong with it. So let's talk about it. So we need a holder. We already know who our holder is. Okay? We talked about them. They get the document. But what constitutes value? Number 2. Holder in due course has to give something for it. Okay? This isn't not like consideration. It could be in an extent, but it doesn't have to be. Like, value is a bigger picture, and I'll show you the difference in a second. But they have to give something for it, and we have value given in one of the following ways. A transferred for a promise of a performance. Okay? Transferred for a promise to a performance, to the extent that it was actually performed. So let me just give you the distinction here, because this is where this one arises, consideration of value. You agree to buy my car for $1,000. This is a contract. We've talked about that in contract. You agreed to buy my car for $1,000. We have an agreement. We have a meeting of the minds. We have a promise for a promise. You promised to buy my car for $1,000. I promised to sell you my car. The consideration is the stake in the game. I'm throwing in my car. You're throwing in $1,000. That's consideration. But nothing's been performed yet. Okay, so you have to actually have the value happen. We actually have to have the transfer to kind of get to the value component. The second thing is you take the negotiable instrument as a satisfaction of a previous debt. This is a much more common example. So Ivan owes Marta $2,000 on a past due account. Ivan negotiates a $2,000 note signed by Gordon to Marta, and Marta accepts it to discharge Ivan's overdue account balance. Now, Ivan might still owe Gordon, but that's the negotiation here, is that Marta has taken satisfaction of a previous debt, a note. So she may qualify as a holder in due course. She's a holder. So Marta is a holder and she's given value. The third way of giving value, it's actually on the last slide. Sorry, I kicked the button a little too soon, but gives another negotiable instrument, meaning they swap negotiable instruments, maybe a check for a note. But there's some exchange in negotiable instruments. Number 4, acquires a security interest in the instrument or other lien. Remember our chattel paper? This is the example from secured transactions. Credit card company sells David debtor an automobile, takes a note and a security interest. That was a purchase money security agreement. What was the collateral in that? That's the automobile. And now the credit card company or the creditor car company buys the new hydraulic lift from lift company, grants lift a security interest in debtor's note security agreement to secure creditor's car debt to lift company, and the collateral is the chattel paper. That's a negotiable form of an instrument, one for another. So what if Mary is given a $1,000 check for her birthday from Uncle Tom? Would Mary qualify? No. The key here is that she didn't take it for value. Instruments that are received as gifts or who inherits will not qualify for holder in due course. Okay? And the other item here that I want to hit home with value is the value given doesn't have to be equal for the full amount of the instrument. Okay? You can have a discounted amount. And what do I mean by that? And when I say discounted amount, we're talking about a reasonable discounted amount. Back at the financial crisis, 2008, instruments were being sold back and forth, pennies on the dollar, and that was okay. But take these two examples. The purchase of a $1,000 instrument for $950. Probably reasonable. That's why we have this, because you might want to get the money sooner. So you might take a discount just to have some cash versus waiting for the document to come due. You can purchase, maybe there's a purchase on the same instrument at the same time for $500. That might be questionable to give you a holder in due course status. Doesn't mean it invalidates the document, just means it just doesn't give you the status to have greater rights. If the market shows that it's in an excessive discount, it might not be considered as value. So must be in good faith, can't be excessive, but you can discount the amounts, and it won't invalidate value. And good faith, right? Honesty in fact and observance and reasonable commercial standards of fair dealings. That's our definition of good faith. So Ralph issues a check payable to Paul. Laura steals the check, endorses the back, and presents to Quick Check Services for payment. Quick's employees compares Laura's signature to the signature on her ID, and nothing indicates that the check was stolen. If Quick takes this check, could it become a holder in due course? If he's acted in good faith, and that would be what the subjective test of the holder would think. So they check it out, they're taking it for value, they're giving money in return for this document, right, the cashing of the check. And is it in good faith? If they check it out and they think her signature checks out, then it's going to be okay. And I should say that Paul had endorsed the check, otherwise that won't work. Ralph issues a check payable to Paul. Paul had signed it. Laura comes into his office, takes it off his desk, and to which she doesn't even actually have to endorse, but she endorses the back and presents it. The point is, as long as Quick Check Service is acting with good faith, even though the signature was forged, if they don't have any belief that it is, then they are going to be okay. And if they meet the other 2 points here, then they would be deemed a holder in due course and would be able to get further payment. We'll talk about that in the liabilities, what happens in the end when you are the holder in due course. So Rand purchases a $10,000 note for $200 from a stranger on a street. That obviously should raise the good faith flag that's not really standard commercial standards. Very suspicious. So not good faith. there. And then without notice, and without notice of what? A whole number of things, right? The instrument is overdue, dishonored, or that any person has a defense or claim of ownership to the instrument, contains unauthorized signatures or alterations, basically calling into question the authenticity of the document. And if a holder knows of any of these things, they are not going to qualify as a holder in due course. And if they take the instrument, they're going to take the instrument subject to all of those things, just like our assignee would do. And what constitutes notice? When a holder has actual notice, they have to have actual knowledge, I should say, not notice, actual knowledge or reason to know. And that is measured by the objective standard, given the circumstances. What would an objective person in that situation, given those circumstances, believe, whether or not there's knowledge. So, overdue. Ed signs a note for $1,000. Due on May 15th, 2019. On May 16th, 2019, Ed negotiates with me and I buy it from him for $900. Am I a holder in due course? As we know, any negotiable instrument is either payable at a definite time or on demand. This is due May 15th, 2019. The day after Ed's negotiating with me, and I buy it from him for $900. Any problem here? Well, we know it's overdue because it's the day after. So anyone who takes a time instrument the day after it's expressed due date, its expressed due date, is on notice that it's overdue. So I know it's overdue because of that due date. And I should note that while the due date here is May 15th, 2019, the question is how long does that remain? May 15th, 2019, right up until, just midnight. So it would become due the next day at midnight, May 16th. So that's the time window. An instrument that reads payable within 30 days, when does the counting start? The day after the instrument is dated. So Dean signs a note dated December 1st. That's payable in 30 days. When is the note due? It's due midnight on December 31st. So you may recognize that the next day is a holiday. That would be the point. So the payment date falls on a holiday. And if it does fall on a holiday or a Sunday, it's payable the next business day. I offer to sell you a $10,000 note for $9,000. The note was payable last week. There should be red flags all over that, because you might be saying, well, you could demand that payment already from the maker. Why are you trying to sell it to me for less? Right? That's the question here. So you would be on notice under that without notice section, and you will probably, under this case, since it's overdue and past, you would not be considered a holder in due course. So what constitutes dishonored? An instrument that's not paid when it's presented to the party. Numerous examples. There's not insufficient funds in the account if it's a check. But when it's presented, it's not paid. If you have any idea of whether or not that negotiable instrument was presented and not paid, that's not going to give you holder in due course status. Defenses, basically a reason why the obligor won't pay. Claims, assertions of ownership against the instrument, incomplete instrument, any signs of forgery, alterations to the document. Those are all going to be red flags to someone who wants to be a holder in due course, and under that last requirement of without notice.